Ms. Williams, welcome. I see you've brought some guests with us.
I have.
You can introduce them to us?
Thank you. I brought my mother, Nancy Cervetti, and I brought my daughter, Finley. She's my eldest, Finley Williams. And I was going to tell you why later, but I will tell you now. It was really important to me to bring both of these people with me because my mother has contributed so much to who I am, and I really wanted her to be a part of this process with me. And then also my daughter. She has heard a lot of interviewing and what this means, and I thought it would be important for her to see it in action. So they both came with me today. So thank you for having me.
Welcome to our proceeding today, and you now can start your opening remarks.
Carry on. So I want to start by thanking you all for the time and energy that you have put into this. I continue to be impressed with the amount of time you've spent reviewing our application materials and meeting with us in person. I think it speaks to the seriousness of which you take your role and responsibility in selecting the very best judges for Iowa, and I appreciate that, so thank you for your service. It is not my intention to make long remarks today. I got the memo. I know that we want to leave time for questions, but I did want to address two issues before I open myself up for questions. The first is why I would be an asset on the Court of Appeals and what I would bring to this position. The caseload of the Court of Appeals was approximately 49% criminal related. And I looked at the sitting judges, and I believe that Judge Bauer had a few years as a city attorney and as a Blackhawk County attorney. But other than that, there is no one on the bench right now with any prosecution experience. And the role of a prosecutor and the perspective of a prosecutor is really important. We understand intricately issues of constitutional criminal law. We understand the ethical obligations imposed on the prosecutors as agents of the state, but we are also trial attorneys. We understand a record. We understand how to make a record, the importance of a record, what a good record looks like, the significance of things in a record, and also the significance of when things are missing from that record. And that ability and understanding and perspective is important given that at the appellate level in the Court of Appeals, the record is the file. And so I would bring that to the bench. I would also bring, though, not just my trial attorney experience, but also my appellate work. In Iowa, the Attorney General's office is primarily responsible for handling all the criminal appeals. And so while you may have a state court prosecutor who's a trial attorney, they do not do criminal appellate work. And you may have an appellate attorney who also is not a trial attorney. The state really bifurcates those two responsibilities. But at the federal level, we do not do that. I am responsible for handling all of my criminal appellate work to the 8th Circuit. I don't have interns or law students who help me write those briefs. That's work that I do myself. And the practice of appellate law is actually pretty unique. It's important to understand the different standards of review, how they apply, when you apply them, and how they differentiate from each other. And you need to do that to be able to be successful at an appellate practice. And so that is an asset, both my trial attorney perspective, but also my strong appellate work are assets that I would bring to the Court of Appeals. I know that some people may argue that a federal practice does not translate well to state court experience. And I believe that there are actually more similarities between the two than may be commonly thought of. First, 13% of the Court of Appeals work is post-conviction matters, habeas post-conviction issues. The state legal framework to analyze those issues follows the federal work. Those two issues are the same in terms of the legal analysis applied. And so that's just one example of how a federal criminal law practice is going to be applicable and useful in the Court of Appeals. But second, I, as a federal prosecutor, am required to analyze Iowa law, statutes, and jury instructions on a regular basis. I submitted a writing sample that I hope demonstrated that to some of you, that this is actually something that we deal with a lot. And so I am seeing statutes, case law, jury instructions, and on a regular basis, and I don't see my federal work as a detriment. I see it as an asset because I understand both systems, and I understand when they intersect, but also where they diverge. Second, I would like to address my lack of district court experience. I do not believe that district court experience is necessary to be seated on the Court of Appeals. I think that our current Court of Appeals court, in fact, demonstrates this. We have 4 of the judges currently sitting on the Court of Appeals who have no prior district court experience prior to being put on the Court of Appeals. And I took a moment before today to go through the Iowa State Bar Association judicial evaluations. And every 2 years, the Bar Association sends out evaluations to attorneys who appear regularly before various judges in preparation of the retention election. And I looked at the most recent survey that was on the Bar website. That was for 2016. And of the Court of Appeals judges up for retention, the one who got the highest retention rating from the bar members, from the attorneys, kind of their scorecard, had no prior district court experience. And I think that that demonstrates that this is not a prerequisite to succeed at this job, that people are on the bench now who don't have this experience, who are great judges. And if we use prior district court experience as some sort of litmus test, we may miss out on some really qualified candidates. I'm applying for this job because I think that it would be challenging and fulfilling, but because I believe that I would serve the people of Iowa well. I very much appreciate the chance to come back in front of you all, and I look forward to your questions.
Thank you very much, Ms. Williams. We'll start with Ms. Pearson, if you have any questions.
Thank you. Thank you for your application, and thank you for being with us today. There are several people that have served our country here that are applying, and I want to thank all of you and who have done that. And would just like to ask, how do you feel your military experience kind of prepares you and would benefit your serving on the Court of Appeals?
Sure. So I think it benefits in a lot of different ways, but one that I've mentioned to some of you is that I really can bring an understanding of kind of what we refer to in the military as a chain of command. The role of the appellate court is to, by rule, justly and fairly and swiftly dispose of cases. And that's kind of, I think that I can understand that mentality and bring that to this position. The role of a Court of Appeals judge is to make sure that the Supreme Court doesn't have to do extra work, and also make sure that things are moving along and getting the mission done. And so that kind of mindset is something that I think that I would bring to this job.
Thank you.
Ms. Bowden?
Yes, thank you. You have a very successful practice, and you're a very talented, gifted woman. Why now at this stage of your life do you want to proceed to an appellate court?
So I am at the stage with my criminal practice where I enjoy it still, but the issues and challenges aren't as new and aren't as intellectually stimulating as they were when you first started. And so I really enjoy challenging myself intellectually and coming up with new issues and confronting things for the first time and working my way through them. That's one of my favorite parts about being a lawyer. And so I think that that's why this job appeals to me so much.
Thank you.
Mr. Berger?
No questions.
Mr. Diaz?
Hard to believe, but I have no questions.
First time.
No
Ms. Law?
No questions.
Mr. Bevel?
No questions.
Mr. Sukup?
No questions.
Ms. Sinclair?
Have you ever applied to be a district court judge?
So I've applied to be a federal district court judge, but I have not applied for a state district court judgeship. And I will tell you the reason why is that there's not been an opportunity. I am in the 6th Judicial District, and Judge Besler was the most recently appointed judge from that district, and that happened this past summer, which is when my Supreme Court application was pending. And so it seemed a little much and difficult to do both at the same time. There hasn't been an opening since then, and there wasn't an opening for quite some time before that.
Ms. Diekma?
Thank you. I see that you volunteered to coach a mock trial team of high school age?
Yes.
Okay. What is the most important thing that you think in your role to teach those kids about the law or being a lawyer? What do you want them to take away from that experience?
I try to promote a respect for the law, and it's funny because high school students, first of all, I don't know how many of you have high school students of your own. They are their own breed. And they absorb so much from TV and movies. And so the first challenge is explaining to them that the practice of law is not like what they see on TV. But also trying to explain to them that really that us attorneys take these ethical duties and oaths, and we are proud of the work that we do, and why it's not about winning or being right. It's about respecting the system that kind of our country is founded on. And it's more about instilling that respect of the law into them than anything else.
Thank you.
Mr. Goodman?
Yes, thank you, Your Honor. First of all, thank you for your application. I want to drill down a little bit on your experience as an appellate lawyer. And ultimately, I'd like to know, do you think there are people that are qualified for appellate courts that may not be ideally suited for district courts? In looking at your application, you've got 90 cases that were before the Federal Circuit. 79 of those were as sole counsel, 2 as chief counsel, and 9 as associate counsel. The question that relates to trials lists 15, but that's in a 10-year period, and I think you've been in practice about 15 years. Would your jury trial experience be any significantly greater if we expanded that question to the 15-year term?
It would probably be greater by about 25%.
Okay. And I'm not an appellate lawyer, so this would benefit me, but for the lay people, it might help also to explain, not in depth, but just briefly, when you get up on appeal, most cases are not a de novo, like do-over, let's take a look and see if everything was all right. It's more of a, wait a minute, there's a standard, and it's a keyhole standard that you're only gonna get through, and you're looking at some very narrow issues, and the review is sometimes very narrow. Could you briefly explain that and how appeals are unique in that regard?
Absolutely. So de novo, I think, is the easiest type of review for a Court of Appeals judge, because you get to consider everything and make your own decisions. But as Mr. Goodman stated, that's quite rare. What's most common is an abuse of discretion or a clear error type of standard. And abuse of discretion, what your role and responsibility is to not fully judge the district court, but instead say, did the district court abuse its discretion? Did they do something that really they should not have done? And kind of the mantra is, even though I as an appellate judge may not have reached that conclusion, and I may not have agreed with that judge, did the conclusion that they reached so much fall outside the heartland of cases that we really need to do something about it? Or does this fall within their discretion? And that's what I mean when it's really, an appellate practice is its own beast kind of on itself, because you need to understand the role that abuse of discretion review has. And then clear error too is slightly different, but it's the same kind of question. Did the judge clearly err in making this decision? Because the role of the appellate court is not to retry the case. It's not to grant a whole do-over. It's to make sure that the district court did not abuse its discretion, did not clearly err, and that the outcome falls within the heartland of what is considered just.
And one last question to follow. Do the federal courts and state courts differ in terms of what's known as plain error?
I don't believe that they do. That's also a different, yet another fourth standard would be the plain error review.
Okay, thank you.
Mr. Bloom?
No questions, thank you.
Ms. Conover?
No questions.
Roberts.
No questions.
Ms. O'Brien?
Yes, please, thank you. Ms. Williams, I actually have two questions. The first one is, according to your application, you have some experience in e-discovery. Would you please explain e-discovery? Maybe identify some examples of issues that come up in e-discovery, and describe for us how that might assist you if you were appointed to the Court of Appeals.
So e-discovery refers to electronic discovery, and probably starting about 15 years ago, it really became a hot topic in the law with businesses and corporations electronizing everything and keeping a digital record. The amount of data that they kept was tremendous, really outstanding. And one of the reasons why it's costly to try a civil case is because there's so much more discovery, specifically e-discovery now, to wade through and process. You would have, for example, emails. Maybe it would be a discovery issue. I want all this emails of the CEO of this company. And maybe she's written 10,000 emails over the course of 2 years. Some of those are going to be with her attorney. Those are privileged. We can't produce them. And so do we have to go through individually every single email? That takes a tremendous amount of time. It costs so much money. And so when we're talking about e-discovery procedures, for example, one of the things that we've all kind of agreed to now that's common but wasn't 15 years ago are clawback agreements, where we say, okay, if we turn privileged things over by mistake, we can take those back. My experience with e-discovery that I've mentioned is fairly extensive from my civil practice. I sat on the Washington State Bar Association's Court Rules and Procedure Committee. I was on the e-discovery subcommittee, and myself, along with 5 individuals in Washington State, wrote the Washington State civil rules to address e-discovery issues. And so we confronted these, we prepared these, we really thought about those. And I think that that's an important asset that I would bring to this bench, is understanding e-discovery and the changing role that it has. And I'm going to stop talking because I know you have another question, Ms. O'Brien.
Thank you. My second question is, we discussed the disparate impact of the criminal justice system on minorities, and I wondered if you have given any thought to that, as to what role, if any, the Court of Appeals might play in that issue. And probably more important, whether you have participated in any activities that would address the disparate impact.
So I thank you for the question, because that is a very important issue. And that's why I think it's important to have a prosecutor's perspective on the Court of Appeals, because the disparate impact on racial minorities in the criminal justice system is real. That's a real issue that not our state faces, but the entire nation is facing. The assets that I would bring to bear on that is, first of all, I think one of the best ways to deal with it is through educating the bench, as well as the legal community as a whole. And that's something that I would be able to use this position for, is to push for making sure that we have education on implicit bias and unconscious bias when it comes to the criminal justice system. And then me personally, I have sought that education as much as I can. Judge Bennett gives an amazing presentation on implicit bias. There are some websites that you can go and score your own implicit bias on and start to recognize where you have weak spots, because it's pretty well determined that the first step in reducing your implicit bias is to recognize it. And so that's something that I've tried to take on and be conscious about.
Mr. Horbach?
I have no questions.
Mr. Gray?
I have no additional questions. Thank you.
I don't have any questions, and we really appreciate your appearing today, and your daughter did a wonderful job back there, and you should probably buy her something nice on the way home.
You know, I sat around that side because the cameras pick up this side, and I didn't know what she would do, and I didn't want it to be burned in posterity on YouTube. Thank you all so much.
Thank you very much.
She has all the lights counted right now, so.